I'm Peter VanValkenburgh. I'm the Director of Research at Coin Center, which is a Washington, D.C. based nonprofit focused on cryptocurrency policy, but I'm also a member of the Zcash Foundation Board of Directors. Coin Center has been around for 4 years now, and our mission is to defend the freedom to innovate using open blockchain technologies, and that means Bitcoin, Ethereum, Zcash, and the like. And really we do three things. We do education, policy research, and advocacy. There are three main branches of regulatory policy that touch cryptocurrency: investor protection, consumer protection, and anti-money laundering, or counterterrorism financing, which you could also call financial surveillance because it's about the government collecting information that could lead to the arrest of those laundering money or financing terrorism. There's also tax, but I hate talking about tax. On the investor protection front, what we've seen over the last year, 2018, has been increased interest of the SEC in people who are creating brand new cryptocurrencies, making promises about them, and fundraising in order to develop that software in advance of releasing the open network. That pre-funding or pre-sale or pre-mine activity in some ways could fit the US definition of what is securities issuance. And if that's true, to the extent that that's true, then there are a lot of people who need to comply with securities laws in order to do that fundraising compliantly. And most people haven't. The ICO boom has largely been a story of people not complying with those laws. So that's been a hot spot. What's heartening about that progress has been that recently the SEC, which has had a steep learning curve and has actually done quite well getting up to speed on the fundamentals of the technology, has come out and said, look, for the truly decentralized cryptocurrencies, and we've heard this from Chairman Clayton and from Director Hinman at the SEC, for the decentralized cryptocurrencies where there is no longer an issuer upon whom people really are relying, people are relying on open source software and an open network of people participating in the consensus mechanism, those things, those tokens and coins are not securities according to our read of the relevant law. And so that's great because frankly, if all cryptocurrencies, especially the decentralized ones, were to be treated as securities, it would be horrible for the progress and innovation of this technology in this country because it would put up so many roadblocks and it simply wouldn't make sense. Who's the issuer of this thing that is now actually part of a decentralized network where we rely on everyone instead of one person? On the consumer protection front, it's always been a focus on the exchanges, really. So the exchanges are the companies out there that you can regulate for consumer protection purposes. They're where most people go and they buy the thing, and they're where a lot of people go and store cryptocurrency. So there the story's been about money transmission licensing in the US, which is basically a consumer protection approach that says only certain people should be allowed to do this activity because it has this risk where you could lose the customer's funds. And so we're going to ask that people get a license in order to perform that activity. And every state in the US regulates money transmission licensing differently. So some states, those laws apply to an exchange, and in some states they don't, and in most states it's unclear whether they do. And then a few states like New York have created new licenses, like the BIT license, as a way of creating a separate licensing regime specifically for virtual currency companies or cryptocurrency companies. So that's been progressing, although there's still lots of uncertainties, as I said, about which states will actually require a license and some just won't. And then the last thing that I was going to talk about was anti-money laundering policy. And this is not a state-enforced licensing law. Anti-money laundering policy is a federal government-enforced law where if you are a money transmitter or something like a money transmitter, and there's a separate definition for that, which may cover a lot of exchanges, then you're obligated to register with the federal regulator, FinCEN, and collect certain information about all your customers and file suspicious activity reports and keep all that information up to date. You basically have to surveil your customers. And this is all a product of the Bank Secrecy Act, which is a statute that was passed back in the 1970s, which started this sort of surveillance regime with respect to your financial records. And interestingly, we talk about warrantless surveillance in the context of things like emails and the Snowden revelations. We don't usually talk about it in the context of our financial records, but almost all of the data collected by our financial regulators is collected without a warrant. And we've actually according to the Supreme Court in a 1976 case, given up our reasonable expectation of privacy over our financial records with respect to our Fourth Amendment rights, because we handed them over to a third party, and therefore we made them effectively in the public domain, which is kind of strange. I think a warrant requirement for investigations into your financial bank records might be reasonable, and that's a big part of why I believe in privacy-protecting technologies like Zcash.